brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
So, arraignment. There are two things that arraignment can mean, right? One is a meeting that they officially title the arraignment. Okay? And two is what that actually means, which is when you are informed of what you're accused of and are expected to respond to it.
Okay, so that could be when we first walk in to the magistrates.
Again, I don't care about what they call themselves. Call them, whatever the hell they call themselves. Judge, magistrate, titles don't matter a bit. Because basically it's the opposition. It's the other guy.
And then they don't ever even have a prosecutor ever. It's always just...
Betcha they do.
Oh, they do? Yeah, the magistrate.
Because there's two meanings of the word prosecutor. One is a guy who officially has that title, and two, a guy who's prosecuting you. And there's someone prosecuting you. Even if he doesn't officially... That's like saying there's no janitor. Right? It's like, okay, let's not be coy. There's not a guy who's officially called janitor who fucking runs the vacuums. Right?
Yeah.
Don't play games about he's not officially a janitor. They may be, there's not a janitor. He's the cleanliness custodian. I don't know what the hell, the cleanliness engineer. It's like, don't play games. It's like, all right, there's somebody who is accusing me of wrongdoing. Right?
Yeah. So
there we are.
Like those codes hearings that they have, they're civil, right?
What do you mean by civil?
Like a civil proceeding?
You can't use the word. Okay. You can't use the word I asked you to define, but what do you mean by civil? You can't use without using the word civil.
Like the opposite of criminal.
Still not helping. Okay, we know that what you mean is not criminal. Okay, that's fine. But what is it? I don't know
how else to explain it. I mean, when how there's two types of courts, either criminal proceedings or civil proceedings.
I have no idea. Two types of courts. You mean one has one color and another has another color?
No, I don't know how else to explain it though.
I know. I'm being a little bit coy here.
Okay.
The reason is that there's not a physical difference between the two things, obviously, right?
Well, there's a procedural difference.
Well, how do you know?
Well, because I tried to ask them questions about one, and they told me, well, that doesn't apply because it's not criminal.
Okay.
And then
here's a trick.
Okay.
Ask your questions in a manner that doesn't give a shit what they call it. For instance, instead of asking, is this criminal or civil? You ask, what is the prosecutor's burden of proof? Does he have a burden to prove things beyond a reasonable doubt? Or does he just have to prove them a little bit?
Yeah.
What else? What else might you want to know? Because you're trying to say, is this criminal civil or criminal? But I suspect you're actually trying to get at a deeper answer. And instead of asking the direct question, you're trying to infer it from the answer, whether it's criminal or civil.
Yeah,
I
forget what my question. Well, the reason why it's important, I think, is because does it have to do? I think the reason I was thinking it was important was because of the way they look at whether or not there's a valid case or controversy, or if it was a crime.
So you're trying to use that civil versus criminal thing in order to get actually at a different piece of information.
Yes.
Right? And why don't you just ask for the piece of information you really want?
Well, because what I'm worried about is if I could ask them that and get them to admit to it just outrightly, what the thing I want to know is whether or not there's a corpus delicti, or if there's a
What do you mean by corpus delicti?
What I mean is like, okay, so like if there was an actual crime or
What do you
if
mean
it
by
was
an actual crime? Oh, okay. I'm sorry. We're really okay. Let's get a few basics down because you keep going to things that are a mess. Okay, and I'm with you. I understand the problem that you're having. I really do. I'm just trying to point out the nature of how your brain is going to things, and you're okay. So let's try it this way. So you're asking about a corpus delicti. Why are you asking about corpus delicti? What is it? Is that really the answer that you're trying to go after, or are you trying to go after something that's beyond that?
I'm trying to find out what the elements are of a valid cause of action.
Okay, that's your end goal, is to figure out what the elements are of a valid cause of action?
I think so.
Or is that just a step to get to your end goal? So if I told you the elements of a valid cause of action, you'd be like, great, my life is done. My life is complete. and that's all I needed.
Hammer on the fact that there isn't a valid cause of action, I guess.
Okay, so you seem to be presuming that there needs to be a valid cause of action. Is that correct?
Well, I was assuming because I thought that there did need to be one.
Okay.
To have.
I'm okay with the idea, but let's get it confessed by them instead of you asserting it.
Okay, so what do I need to have them specifically confess to?
Okay, so you're presuming that there needs to be a valid cause of action, right?
Well, I'm presuming.
Instead of presuming it, how about we ask them?
Okay.
Does there need to be a valid cause of action to proceed here today? Now, what do you think they might say to you?
This is just an administrative hearing. We're just here to, because you violated a code.
Okay.
I don't know.
So would that be an answer to the question? You asked a yes or no question, right? Well, me in your place. we asked a yes or no question, namely.
Okay, so no, they didn't answer yes or no, but basically by what they said, they weren't answering.
You're presuming that means yes or no?
Well, if anything, I was presuming that it meant no. But no.
Why?
I wasn't trying to
one of the biggest lawyer tricks out there is to give you a big old sentence that makes you think they said yes or no when they didn't commit to that at all. So that you cannot later come back and say, but you told me blah, blah, blah. And you can say, you are a big, fat, dirty liar, and I can prove it on the record, and I think you should be charged with contempt for lying. The principle involved here is if you want to ask a question, yes or no question, don't read into their answer. Take their answer literally and don't interpret their answer.
Okay.
Because if you interpret their answer, they can mislead you by causing you to interpret badly. And believe me, they're good at it. I could probably have your head spun around and make you think I'd said yes when I'd said no.
I would have to agree with that.
And you'll discover as you learn how to hear what they're saying, when they're misleading or whatever, you'll start noticing in these recordings and stuff that we have of judges that it's like, holy crap. Thinking back, I would have totally thought he meant yes. And now that I'm listening to the actual words he says and in context of what we know, he totally said no. You know? Mm-hmm. So it's weird how all that works. It's a very confusing thing for people. And it's very normal for us in our normal lives and conversations to kind of round up to the next nearest intent. Like, I'm going to interpret that as a yes. You know what I mean? Or no. You just kind of give it. You don't get all lawyerly on people, you know? Okay, so asking if a valid cause of action is needed. So if you come back and say, listen, I just really trying to understand things here, and I just need to know if yes or no, valid cause of action would be necessary. they'll probably come back at you and say, what do you mean by a valid cause of action? Like I did to you earlier. Because if it's something lawyers don't like to do is commit to a position. They don't want to say anything that can come back to bite them in the ass. Their whole job revolves around getting people to say things that they can use to come back and bite them in the ass on. That's what they do for a living. So it's certainly something that they don't freely do, except when they're really crappy. So you'd be asked what you meant by valid cause of action. Because you made up the word. It's not something that they put in their pleadings. They didn't write that in the accusation. You are accused of, this is a valid cause of action against blah, blah, blah. You brought that term into play. Now, it's a good term to bring into play in a cross-examination of a cop. Completely different context. Great question there. Because that cop is going to want to say yes. And that's when that's a whole different situation where we're trapping him into sticking his foot in his mouth, right?
Well, just say it's the codes officer, because he's going to be, they don't ever bring up a prosecutor in. It's just the judge and the codes officer and I.
Okay. Sorry, there's two different stages of things.
Okay.
One is where you're being informed. There's more than two, but obviously the two that I'm talking about is one, where you're being informed of what you're accused of. And then way down the line, after you've prepared your defense and all that kind of stuff, and they've presented their case, so to speak, and they've presented their witness, when you're asking that witness questions.
But it's usually the same person. Sorry, go ahead.
Doesn't matter. I don't care if there were 18 people in between.
Okay.
Way down later, you're cross-examining somebody.
So let's say
that earlier had accused you of breaking a law.
Right. So let's say it's the codes officer.
I don't care who it was.
Is doing his testimony, and then I get a chance to do cross. And I'm asking him this.
He in his testimony, he said that you broke a law, correct? That you violated a code. Right. Okay, so something he has said in his paperwork and on the stand and whatever else, he has definitively said that you broke a code. Agreed? Right. This is the guy. All right, yes. Now, he's said that you broke a code. The question comes to him: have you filed? I don't know if you'd say have you filed a valid complaint? But it comes to the same thing. Another angle of that same issue is, have you accused me, or have you made the determination that I violated the statute? Yes. All right. Is that determination based upon facts currently within your knowledge?
Yes.
Okay. What facts are within your knowledge that lets us know that there is jurisdiction over me?
The code.
I asked for facts, sir. Move to strike.